this morning's docket. Case number 107359, Peterson v. Ferrell.
May it please the court, Richard E. Dietz, representing plaintiffs' appellees. Your Honor, the plaintiffs request permission to reserve 5 minutes for rebuttal.
5 minutes is granted.
A brief statement of the facts in this case are the plaintiffs Peterson, Eilert, and Hladd entered into separate grazing contracts with defendant Ferrell for the grazing of their cattle for the 2008 grazing season. Issues arose concerning the care and the condition of the cattle during the 2008 grazing season, and plaintiffs filed suit for breach of the grazing contracts. The matter was tried in a bench trial in Butler County in the spring of 2011. The district court determined that defendant Ferrell did in fact breach the grazing contracts and entered a judgment for damages in favor of the plaintiffs. Upon appeal by the defendant, the Court of Appeals dismissed plaintiff Peterson's action for lack of legal standing and reversed the Court of Appeals' decision on damages in regard to the lost calf crop from the number of open cows over and above the 92% industry standard pregnancy rate, which was adopted by the district court and reversed by the Court of Appeals. The plaintiff Peterson brings his petition for review before this court, arguing that he does have legal standing. In reviewing the grazing contracts for Peterson, there were 2 grazing contracts. One was what we refer to as a cow-calf grazing contract for the 2008 grazing season, and that contract was prepared by the defendant, appellant Mr. Ferrell, and it referred to Mr. Peterson. It was Steve Peterson doing business as, in that case, a corporation, Oak Creek Land and Cattle. There was a separate contract, grazing contract, and that was referred to as a stalker contract for yearlings, heifers, and steers that were brought to Mr. Ferrell's ranch to graze during that grazing season, the 2008 grazing season. And that also referred to, and that contract was prepared by Mr. Ferrell, referred to the owner, or the grazer, or not the grazer, but the one contracting to have the grazing done, as Steve Peterson, again, doing business as NPK and LLC. The contracts were one contract, the 2008 contract, which was presented and admitted into evidence in court, was not actually a signed contract. Neither one of the parties could locate the actual signed contract for 2008, but they both stipulated and agreed that the contract would be the same as the 2007 contract, and that is what was admitted into evidence, and that does show Steve Peterson doing business as. And there's no signature. It just simply shows a line for a signature by each one of the parties. The stalker contract was the signed contract for 2008, and that was signed by Steve Peterson and dated by Mr. Peterson and signed by Mr. Ferrell. Plaintiff Peterson said,
Counselor, let's cut to the chase. Who owned the cattle?
Cattle were actually owned by Mr. Peterson.
I thought he testified that in one regard that he, a son, and a hired man, or had formed the LLC or the corporation or whatever. I thought he testified that there were others involved and that it was either a corporate entity or a limited liability company.
Mr. Peterson testified that essentially those entities and him were one and the same. Now, some of the cattle that were brought down for the grazing Some of them were owned by others than Mr. Peterson, but Mr. Peterson is the one who contracted with Mr. Ferrell for the grazing. He was the one who took responsibility for seeing that the cattle were grazed.
Your argument is that Mr. Peterson was not the owner of the cattle, but he was the party in the contract.
Exactly. And that he does have a justiciable interest in this matter. He has a property interest which is affected. He owned the corporation, he owned the LLC. If the LLC, if given the argument that if it were owned by the two entities, because he was the sole owner, if it lost money, either one of the entities, that was certainly going to affect Mr. Peterson adversely. He does have an interest that's affected here.
Don't we have some case law that says even though there's a flow down damage to the shareholders, nevertheless they can't share or they can't sue to obtain a corporate remedy? And we have some cases that say that obviously shareholders get hurt when the corporation gets hurt, but that doesn't give them standing to sue in the corporate name, or sue in their individual name for a corporate remedy.
Well, certainly they would not be able to sue the corporation. I understand what Your Honor is saying, but I think the key here is Mr. Peterson, given his relationship with those corporations, he is the one who really, as you say, it flows down to him. He's the one who really has standing because he's the one that loses because of the damages which we allege and which we believe we proved in the district court.
Counsel, was there ever a motion to amend at the district court to bring these LLCs into the action?
No, Your Honor. The second issue, which the plaintiffs, all three of the plaintiffs, Mr. Peterson, Ladd, and Eilert petitioned the court for review on, is the decision by the Court of Appeals to reverse the decision of the district court granting damages for the what we refer to in the livestock business as a lost calf crop. The Court of Appeals reasoned that the damage should be the difference between the value of what's referred to as an open cow, a cow which is not pregnant, and one that is pregnant. And that is the excess over a 92% pregnancy rate, which was found by which was affirmed by the Court of Appeals, that the only damage should be the difference between a bred cow and an open cow and that excess number over 92%. We argue that a damage should be also the lost calf crop, that it's not a windfall as was referred to by the Court of Appeals. Farmers and ranchers at the end of the year, the beginning of the year, they meet with their lenders, they list the number of cows that they have and whether they are bred or unbred. They also, in getting their line of credit, also show the number of calves that they have. In other words, the projected number of calves. There's a damage to the plaintiffs because they did not have then a calf crop from the excess number of cows that were open that they could then market in that following year.
Counsel,
and these are things.
Is there evidence in the record to indicate percentages on live birth, for example, of calves, and then percentages from their birth until they can go to market? There was a lot of testimony and evidence about percentages on putting weight back on cattle and also pregnancy rates, if you will.
Yes.
So I'm asking, is there any evidence to go forward past the fact that the heifers are now bearing fetuses?
No, Your Honor.
So how are we to award any damages for calves that would be placed on the market? if there's no evidence to suggest what they would be worth? Aren't you asking us to assume that for every cow that becomes pregnant, that there will be a successful birth, that will be successfully raised to sale barn date and then sold?
That is correct, Your Honor. That is the way it was presented to the court. In other words, the excess number of open cows. There was a calculation then that was presented to the court as evidence of that number, and then times the market prices at that time, and which we had evidence of that. And that was not controverted in any way. But to answer the court's question, again, no, there was not evidence of a percentage, perhaps the court's referring to death loss. No, there was not.
And isn't that reality? I mean, isn't it a reality that you can't plan on every pregnant cow producing
I think
a
that is
calf
correct.
that will be marketed? And so you're asking us to speculate, or you're asking the court to speculate?
Your Honor, I'm sure that's right. In fact, it's very difficult to put any type of percentage on that.
Isn't the effect of the market to, in a sense, take those factors into consideration when the market sets a different value for an open cow versus a cow that's carrying a calf? In other words, there's an increased value, and your clients were awarded that value as damages, correct?
That's correct, Your Honor. If I understand the court correctly, there's no correlation between the difference between the open cow and a pregnant cow and what number of calves that they might have had would have actually made it to market.
I think Justice Stiegel's asking you if you go to the auction and there's an open cow and a bred cow, are you going to pay more for the bred cow?
Absolutely. Your
And
Honor.
that increase in value contemplates that the cow includes the risk that you will actually get the cow and be able to market it a year from now after you put production expenses into it. So he's asking, isn't that already factored in to that difference in value? And so that's the loss that your clients experienced.
My opinion is,
That's exactly what I'm asking.
my opinion is no. I realize that. I think if I understand what you're stating, that already the value of the bred cow factors in what that calf is going to be worth down the road. And Your Honor, I submit that no, there's not a correlation there with what the calf will be worth down the road.
Why are you paying more for the bred cow then?
There is a potential, Your Honor, but at that point in time, it would not correlate to what the calf would be worth down the road.
Well,
Because
the reason it's not as valuable, it costs less, is because it's a discounted rate. It's discounted for production costs and risk of loss and these other factors which are speculative. So the market figures all of that out simply by the price setting mechanism. It's a discount. You're paying a discounted rate from a live calf, but you're paying more than an open cow.
I would submit that probably the biggest reason for the difference in that value is because you've really lost a year and you've got to wait another year. In other words, probably that biggest difference is because of that loss of a year. In other words, you're going to skip a year in which you're going to have production.
Any further presentation
No, Your Honor.
on any issue?
Well, Your Honor, I can address the issues that have been petitioned by the defendant appellee. The defendant appellee argues that there wasn't a breach of contract. But Your Honor, we submit that there was a very clear breach of the contract. Certainly, it's contemplated that looking at the argument of the appellant. It appears that what he's saying is that all I should be responsible for is bringing the animals to me. I put them on pasture. Nature will take its course. I don't have to return the cattle in any better shape than they came to me. What I find interesting is in the contracts that he prepared, he talks of, I will not be responsible for any body condition score, which is referred to in the contracts of less than 4. Why then could he argue that it doesn't make any difference how he would return the animal? Certainly, if he wants the cattle to be of a certain condition when he receives them, he should contemplate when he contracts that he's not going to return an animal that has deteriorated in condition. And it's also, I'm sorry.
Can I ask you, stop you there and ask you, is there any difference between the two contracts? I mean, it seems to me that the underlying or overarching purpose of the two contracts is somewhat different. Stalker contracts, you want to put weight on them because you're moving them from stalker to feeder, and the weight gain is pretty critical. A cow-calf, you just want to keep them healthy so they get a cow or calf, and the weight gain isn't that important. So when we're looking at whether there's been a breach, is there a different lens we look at these two contracts through?
Certainly, Your Honor. One of the big issues here was the low pregnancy rate, and I'm sure if the court, as a court in preparing in reviewing this matter, it was very clear during the course of the trial that the nutrition of the cattle was not provided, and that it was very clear from the veterinarian and also an expert witness from Kansas State University that there's a close correlation between the nutrition that's provided to a cow and the ability then to conceive and get pregnant.
So what you're telling me is that really there's not a lot of difference under the facts of this case. Not a lot of distinction that there's a stalker contract and a cow-calf contract because the proof is the same. It's a lack of nutrition.
It is lack of nutrition. Obviously, they were not monitored, as he agreed to do very well. Again, the record, there was testimony from even truckers as to the condition of the cattle, how weak they were, what poor body condition they were in.
Yeah.
That's my answer to your question.
And nutrition is evidenced by the weight gain or failure to gain weight, even for the cow-calf.
Weight gain and the pregnancy rate.
Right, okay.
Could you remind me, the sentence in the contract, or at least one of the contracts, says grazers shall provide feed and mineral to owners' cattle according to the seasonal nutritional needs of the owner's livestock, close quote. I understand the evidence about breach, or about damages. What's the evidence about the breach of that? What standard does that language create? And then what's the evidence that that standard was breached?
Well, again, Your Honor, there was evidence as to the poor nutrition. In fact, how they were left, they refer to paddocks.
And I understand that, but I'm trying to get at how do you identify what that language means?
In the contract, well,
Yes.
certainly monitoring. If you're monitoring and caring for those cattle, as Mr. Ferrell agreed to do, they wouldn't be, the things that happened would not have happened. The low pregnancy rate, the loss of body condition in regard to the bulls, their condition resulting in death loss, as well as in such poor condition they could not be used again.
Their argument, as I understand it, is that they only had to go out and feed when there was snow on the ground. And that language seems to say something different to me, but I'm trying to, and it seems to communicate to me an industry standard that I'm not terribly familiar with on a normal basis. So I'm just trying to figure out what you're seeing as the standard? I mean, is that an industry standard? Is there a professional standard that says you got cattle out there, this is the way they should be, the nutrition they should be provided and how they should be fed?
Well, certainly, Your Honor, and again, the proof is in the pudding. These cattle were not cared for. In other words, he agreed to monitor them and provide proper nutrition for the cattle. And he did not do so.
How does that argument not make the grazer a guarantor of success?
It does not make him a guarantor. In contract
Proof's
law,
in the pudding, and we got sick cows. By definition, does that mean this contract's been breached?
depends on what the grazer is going to do in the if he's got sick cows or if he sees that these cattle are losing condition. Obviously, he didn't do anything about it. It should be in contract law. I mean, the parties have a right to certain expectations. Certainly, my clients certainly expected that their cattle were going to be taken care of and that they would have a reasonable pregnancy rate, that they certainly would not suffer the body condition that they did. And that's something that Mr. Ferrell should have, that would be a reasonable expectation of Mr. Ferrell, that I'm going to take care of these cattle and I'm going to return them to you, certainly in as good a shape as he received them. And obviously that was not done here.
There are at least two articulable standards in the contract that I'd like to talk about. One is the grazer agrees to provide prudent veterinary care when necessary, and I believe there's evidence in the record that the calves needed a second round of vaccinations, and that was not performed.
That is correct, Your Honor.
And also, he agrees to optimize the quality of grass available to them, and there's evidence in the record, I believe, that they were kept too long in the same paddock. Is that correct?
That is correct, Your Honor.
Okay. Getting back to Justice Biles' question, we're trying to find, is there anything similar in terms of an objective standard when the grazer agrees to provide feed and mineral to the cattle according to the seasonal, nutritional needs? Is there any kind of an industry standard that we can peg his performance to, besides just looking at the fact that they did not gain weight? In fact, a lot of them lost weight.
Your Honor, I would submit that the industry standard would have been established by the testimony, if the court recalls, of Dr. Bechtel, the veterinarian, and certainly also the expert witness from the professor from Kansas State University. I mean, that they would have established, or they did establish by their testimony, as to what is a satisfactory industry standard. That's one reason that the reference to body score is used, and it's even used in the contracts.
They testified to standards about the results, and we're trying to figure out whether there are also there's also evidence of standards about what happened during the term of the contract, not just the results at the end of it. Do you understand that distinction? Are we
Well, I
clear?
believe I do, and I believe that's
Okay.
what Chief Justice Nuss just referred to about there was obvious, clear evidence in the record of leaving cattle in a certain paddock without sufficient grass.
Let's put those aside for just a moment. He mentioned two objective standards, and then we're trying to go back and focus on the standard recited from the contract by Justice Biles. This provide for the seasonal, nutritional needs of the cattle, and whether your experts or anyone testified to what that means during the term of the contract versus it's obvious from poor results that it wasn't done. Looking at results versus what's happening during the term of the contract.
Well, Your Honor, certainly there was testimony from the veterinarian concerning body condition, and there was a lot of testimony during the trial about what body condition is. And You know, what
Not
each,
just at the end, but also during the term of the contract. And
Yes.
the fact that the animals were suffering during the term of the contract.
yes, in fact,
Okay.
there was testimony, I'm sorry.
No, that's right. I think I understand it now. If my colleagues are satisfied, I've got one other question that's unrelated. Did you want to follow up? Either of you?
No, I'm fine,
No, you're
thank you.
good. Okay, thank you. That's helpful to me. I asked a question earlier, and I don't think I articulated it very well, so I'm going to go back. There were elements of damages for the difference between the industry, what was established as the industry standard rate of 92%, and what occurred in terms of open cows. That was
Yes.
one element of damage. But there was a second element of damages for body condition deterioration on the cows themselves, correct?
Yes, the cost
Okay.
then of the lower court or the trial court arrived at the 200 pounds
Right.
to recover the condition of the animal.
Right, and that's
of
what I
course,
was
one of the-
trying to focus on
Yes.
earlier with my question, is that nutrition, or the provision of nutrition, has basically been made an equivalent for they gained weight or they didn't, on the cows as well as the bulls, correct?
Yes,
Okay.
yes,
I just wanted to make sure I understood it.
yes.
There was evidence of causation,
Yes,
or
Your
not?
Honor.
Okay, so, I mean, there may be reasons that they lost weight besides not enough food. But there was evidence that here, the result that we're talking about was the proximate cause was a failure to consume enough food.
Right, it wasn't a trauma, for example. I mean,
No.
this is something that I think we're struggling with on this guarantor
During the
idea.
course of the grazing season. In fact, I think some very important testimony came from Dr. Bechtel, in which he testified about he made the statement during the course of the year, it might have been fairly early on in the grazing season, that there's a train wreck coming.
Mm-hmm.
If something isn't done here, there's a train wreck coming.
Mm-hmm.
And of course, he testified about the condition of the animals, what was going on from what he observed when he saw the animals.
So just to try to put a cap on this, and correct me if I have it wrong, your belief is that there is evidence in the record to establish what the seasonal common nutritional needs of the owner's livestock were.
Yes, Your Honor.
And it's not just a matter of people from outside of Butler County saying, hey, I hear they have good results in Butler County. I'm going to ship my cattle down there for the grazing season.
No.
And therefore being disappointed, which would make the defendant here a guarantor.
No. No.
Thank you. Any further questions? Thank you, counsel.
Thank you.
May it please the court, I'm Tim Cannell from El Dorado, and I represent the appellant Garland Ferrell, who's present here today. As you're well aware, this is an argument concerning some adjustment contracts. There were several. There were winter contracts, which have a kind of a different scenario. There were summer contracts for cows that were summered on the Ferrell Ranch, and there were also stocker cattle, lighter weight cattle that were brought with the intent to gain weight. Let me just say, first of all, that with regard to the standing, it's clear, and I think the Court of Appeals made a pretty good, succinct argument. We didn't have the right people in this lawsuit to begin with. Mr. Peterson was not the owner. He was given more than one chance to amend during the trial proceedings and did not do so, and the court allowed them to proceed, and we didn't have the right party. So I think that doesn't deserve a lot of second guessing. With regard to the calf crop, the plaintiffs asked for and got from the trial court the difference between a bred cow and an open cow, and the value of that calf a year later, the following fall, sold at the sale barn with no deduction for death loss. That issue was raised. And to me, that's a double dip, and that's what the Court of Appeals found as well. You can't have both. A bred cow, by definition, has a calf inside of her. So when you give them a calf too, or the value of a calf, you're giving them twice as much as they're entitled to. if they are in fact entitled to that.
Would there have been any production costs for the calf,
Absolutely.
vaccinations, that sort of thing?
They're claiming that their figures take into account those production costs and that this calf price represented the net. As far back as 1939, this court held that the principal consideration that a lessee receives in an adjustment contract is the furnishing of pasture, the grass and land that makes up pasture land. That's what an adjustment contract is about. It's much more of a lease than other contracts that we might refer to. That case is Lips versus Ops, 150 Kansas 751. The plaintiffs here got the grass on the Ferrell Ranch during the year of 2008. During the winter, they were provided for with hay and whatever other nutritional needs. They're going to need something extra in the winter because the grass is dormant. During the summer months, the grass is what provides. It provides weight gain for stocker cattle that come and graze there. It also provides gain where cows are concerned because they're raising a calf. And you want to keep the cow's condition up, but you also want to get the gain. You want to grow a calf that you're going to sell in the fall. So the cows are bred at the beginning of the summer. They're also raising a calf. At the end of the season, the calves are weaned and sold.
Did the defense present causation evidence at trial? In other words, did you have an alternative theory as to the ultimate condition of the cows being caused by some factor that was outside your client's control or didn't relate to the contract?
Okay, so there's two answers to your question. One is to the condition of the cows, whether they were thin or not. And the answer was it was very hot at the end of the summer. The grass goes dormant. It doesn't stay green like it did into the fall this year, so there's less nutrition there. Mr. Ferrell called Mr. Peterson and said, we need to feed these animals something. And he said, no, let's let them have the grass. Traditionally, that's what you do in the summer of the year. That's what's so great about the Flint Hills. They eat the grass, they're provided some mineral, and they grow.
Let me stop you there. You're saying Mr. Ferrell called Mr. Peterson, who vetoed feeding a supplemental range cubes, whatever.
Yes, sir.
But the contract says Mr. Ferrell is to monitor the cows and provide additional as necessary. So why was it Mr. Peterson's veto when it was Mr. Ferrell's contractual obligation to care for these cattle?
That's a good question. That's one I asked Mr. Ferrell when we were originally dealing with this matter. He said, I call them and tell them what I think needs to be done. I'm not going to spend their money because they're responsible for reimbursing everything I spend on extra feed and expense. So I call them and give them the opportunity. If they say no, then that's it. And also remember, this is kind of like a lease. It isn't, even though it is a contract, they're getting the use of the grass. And the evidence will also disclose that not once during the whole year that these cows were there on the Ferrell Ranch is there any record of any of the three plaintiffs coming to see the animals. They didn't go look at them. Which brings me to another point. Never in my years of practicing law have I seen so much money awarded on so little evidence. There are no pictures, there are no weigh tickets, there's no feed bills, there's nothing. If these animals were all in such terrible condition...
Wasn't there an earlier diagnosis of magnesium deficiency, though?
In the spring of that year, several of the cows went down with what's called grass tetany. About 13 animals were treated out of 800 cows. A couple of them died, the rest recovered. I don't think that small amount of animals can explain the decrease of 70-some animals in open cows over what they're claiming. Those two don't go together. In addition, the vet's comments about what's going to happen were based on the fact that the hired hand said, we haven't been feeding hay. Well, they had. The records show Mr. Ferrell monitored these animals. There's a sheet that shows every day who looks at the cattle, who died, who was sick, who got monitored, and those were sent monthly to the plaintiffs. They knew exactly what they were getting and when they were getting it.
How can we even get into that, though? That would require us to reweigh the evidence. I mean, you made these same arguments at trial, and plaintiffs made their arguments, and so we're really kind of stuck with just whether there's substantial competent evidence on this point for the way the district court found.
Well, I think before you even get to that, whether there is a conception rate of a certain amount, whether there are body condition scores at the end of the grazing season, that language does not appear in the contracts. They've gone from the results, Justice Breyer, of what happened to, well, something must have gone wrong. So if we're going to make Mr. Ferrell and all the other grazers in the Flint Hills or the Jib Hills or the Smoky Hills responsible for conception rates and for lack of gain on calves, then we better say so. But that language is not in this contract. And if we're going to rewrite what the parties agreed to, then the price needs to change. Yes?
Let me take you back to Justice Stiegel's question of defendant's allegation that there were other reasons for that result other than, and you said you had two answers, and you gave us the hot year and the grass wasn't as good. Was there another reason?
Well, I wasn't sure whether this question covered it, but the other matter is about the conception rate. And we don't know why the conception rate was lower. It could have been venereal disease, trichomoniasis. The bulls were never tested before or after. It could have been that these were very large cows. It could have been a number of reasons, none of which was ever definitively decided one way or the other. We don't know.
Well, it was decided. You had the evidence presented to a trial judge who weighed the evidence, and part of that evidence was poor nutrition can cause inability to conceive. Weighed that evidence and made a finding, and as Justice Biles says, that we're sort of stuck with that. We've already had someone perform that weighing and credibility assessment function.
But before you get to that weighing function, I think you need to find that there's an obligation under the terms of the written agreement for a certain conception rate. And let's remember, these industry standards are averages. Somebody's going to be better, somebody's going to be worse. So if I'm taking in cattle, I'm gambling under this scenario that they've created, that if the cattle don't reproduce, if they don't achieve a certain weight gain, then I'm on the hook for the difference. And that's not written in the agreement. I don't think you can get to where these plaintiffs are going based on these documents.
In essence, you're saying if they don't beat the average, they're liable.
Absolutely. Absolutely. That's what happened here.
But aren't we talking about a difference between a measure of damages and a breach of contract? If the contract was you will monitor the cattle, you will make sure that they get the nutrition they need, and the court says, no, you breached that. You didn't get them the nutrition they needed. And now we say, what's our damages? And we have testimony that that breach of not giving them the nutrition caused a decrease in conception rate, which leads to the damages. So the fact that the contract doesn't say we guarantee a conception rate doesn't really apply here, because we're talking about a measure of damages.
Okay. And the measure of damages we're talking about, at least in part, is a biological process, conception, over which a grazer doesn't have control.
You're saying it's too speculative, that there's too many variables to conception rate.
Yes.
That's a little different argument than saying the damages are too speculative is different than saying there wasn't a breach of the contract.
But I also want to go back to your question about the speculation of the damages. We're talking about body condition scores, which, as far as the weight is concerned, is what the court used. And that can vary. It's subjective. Two people standing on opposite sides of the chute who are experienced can vary by one body condition score. From that, the court says, well, let's take an average. There were 2s, 3s, and 4s, but no count of how many there were of each. So let's just take an average, and we'll award that as damages. I think that's too broad. I think that's not justified based on the evidence. That's why I talk about how little evidence there was in this case.
Can we get back to the question that was asked of plaintiff? Is there an industry standard as to the term shall provide feed and mineral to owners' cattle according to seasonal nutritional needs? You seem to say at the outset of your argument that that's just dependent, especially in the summer months, as nature shall provide. Is there anything else other than the winter months that has meaning for, and was that presented to the trial court?
Two things. Number one, the same contract's used during the winter as the summer.
Okay.
So I think it does have two different meanings. During the summer, I think the evidence was the cows and the cattle don't get anything besides grass and mineral. That's what we're trying to do. Make the sunlight grow, turn into grass to grow the animals. During the winter, they're going to need more feed. They're going to need certain nutritional pellets and hay to to fill them up. So yes, I think there's testimony about standards, but in the summer, I think there's only grass that we're talking about.
I'm trying to figure out, I'm still fixated on the same language that we've been talking about here, the seasonal and nutritional needs. I'm trying to figure out how having that written there is better than a handshake.
I think to answer your question, the way adjustment contracts have been interpreted in the past, that it's the landowner's obligation to furnish the grass. And even though that language is in the contract, if they're going to get anything else besides grass, it's up to the owners to make that decision. The nutritional needs, obviously, in the winter are different.
Doesn't say that, though. It says the grazer shall provide.
Well, he's obviously there, the one on the place. He's obviously the one that's going to distribute the feed, whatever it may be. But to go back to my earlier statement, it's up to the owners. They're paying for it in the end. And if they say, no, we're not going to do that, I don't think they can complain.
Did you make an argument that there had been essentially an oral modification to the contract? And that sounds kind of like what you're saying, is that there was a call placed from your client and the owner of the cattle said, I'm going to relieve you of that. Don't do that. I don't want to pay for that.
We sure did. We did make that argument. That was evidence that was presented at trial.
Council, I'd like to go back to the conception rate.
Yes, sir.
That we were talking about earlier, and looking at a paragraph in the contract that the caption is condition of cows.
Yes.
I'm sorry. I was referring to a different issue, not the pregnancy rate, but the standards that you say that your client should not be held accountable to because there were no standards.
Okay.
Okay. It says owner agrees to deliver cows that either have a nursing calf at side or are guaranteed pregnant to calve during the term of this contract. Okay. Is it the position of the plaintiffs in this case that they were prevented from guaranteeing cows to become pregnant during the term of the contract because of your client's conduct or lack of conduct?
Okay, I'm not sure I understand your question. Your question is, did the plaintiffs complain that my client made it impossible for them to become bred cows because of his conduct?
Yes.
Could you ask it one more time or
Yes.
maybe in a different way?
Well, the language says the owner agrees to deliver cows that either have a nursing calf at side or are guaranteed pregnant to calve during the term of this contract.
Okay.
And as far as they're concerned, I think they believe they have fulfilled that obligation.
They believe that.
Okay. If they have not done that, is the argument it is because of your client's failure to provide seasonal nutritional needs and other sorts of services?
Well, sure, that's their argument. But at least some of the cows that were delivered to the Ferrell Ranch in the spring of 2008 had not yet calved. The bulls go out at the beginning of May. They're there for 60 days. The cows have to get back cycling again in order to breed. Some of the cows that were delivered either had just had a calf or had a calf after they got there and the bulls were already turned out. There are a number of reasons why the cows may not have conceived. And so our position is we don't know. And unless the contract somehow requires a conception rate, we're not responsible. We only get paid under the contract for what's alive at the end.
Well, my point is you don't believe that their allegations about your client's failure to provide sufficient services on the contract is what prevented them from guaranteeing pregnancy, their obligation under the contract.
No, I don't believe that.
Okay. And let's go then further in that contract. It says Grazer is not accountable for the welfare of any cow delivered to his premises, which is in a body condition score of less than 4.
Yes.
Okay? Does that suggest to you that you would be accountable for the welfare of any cow that was delivered? Does that imply to you some sort of a standard that your client would have, that you would be accountable?
That implies to me that I don't want cows that are below a certain body condition score, because they're probably not going to make it to the end, and I'm probably not going to get paid. Let's deliver some cows that we're going to be successful with.
And it further says that grazer will inform owner of any cattle he deems less than BCS4 at the time of delivery.
Yes.
Okay. You don't see there's anything in that paragraph that would suggest you have an obligation to raise a body condition score?
At the beginning of the contract, yes, we definitely do. And later on in the agreement, when Mr. Ferrell thought the cows were thin and needed additional feed, he did raise that and was vetoed by Mr. Peterson. But does that paragraph that you mentioned require a certain body condition score at the end? No, I don't see that. You can certainly make that assumption, but that's my whole argument. This lease of grass has blossomed and grown into something far beyond what the parties agreed to. And we're going to make a lot of people take a lot of risk if that's the provisions that we're going to insert in these grazing contracts.
Was there any obligation under the contract for your client to call Mr. Peterson and say, you need to make a choice. We either provide some supplemental feed or we let him graze on the grass that is not at maximum value right now?
I think
was there an obligation for him to do that?
Well, whether it's an obligation or not, he did that.
Is there an obligation in the contract to do that?
No, I don't believe it is.
Okay. So that brings us back to the question, is there an obligation on the part of your client other than to let these cattle onto his property and let them graze?
I think that's what the obligation is, yes.
Period.
Well, along with some other incidental things, to doctor them as required, to run them through the chute and give them the various shots. I think those are certainly obligations under the agreement as well.
Doesn't the fact that your client called the owner of the cattle to tell him that additional feed, he thought they needed additional feed, doesn't that, isn't at least some evidence that he knew he had additional duties under the contract?
He knew those animals needed additional feed to keep up with
And he knew that it was his responsibility pursuant to the contract.
He was monitoring them, and he called the owners, and they made the decision. Yes.
And when the contractual obligation is to optimize the quality of grass available to them, it would be your position that if nature says the grass is performing poorly, you would say, but as long as my client is optimizing the quality of that poor quality, he's satisfied his obligation?
I believe that's the case, unless the owners want to pay for more feed. I think that is the situation.
All right. Thank you.
Okay. Well, thank you. Let me just say in closing here that I'm asking, and the appellant is asking, that you set aside any judgment based on industry averages, as that language is not in the agreement. That you set aside any judgment based on body condition scores because the damages were not proved with certainty, and that language does not appear in the agreement. That they failed to mitigate, the appellees failed to mitigate their damages by selling open cows and buying bred cows. That you affirm the finding that the Peterson cattle, the owners of the Peterson cattle, were not parties to the lawsuit and there's no jurisdiction. That you affirm the finding that the plaintiff cannot ask for the value of a bred cow as well as the value of a calf on top of that. That you find that the award of damages to buy 4 virgin younger bulls betters the positions the appellees would have been in had the contract been performed. And last, I'd just like to say that we're not waiving any additional claims that we made in our brief.
Let me ask you about the bulls.
Okay.
How else would you do that? Calculate damage.
Okay, so because of the risk of venereal disease, when the bulls are used with the cows, even once, they are no longer really eligible to be sold as breeding animals. Their only value is for hamburger, for meat. So if the contract had been performed, at the end of the season, these 4 bulls that we're talking about would have been used bulls, and their only value, if they were sold at a sale barn or somewhere else, would have been for meat. But what they got was younger bulls, virgin bulls, that would have lasted longer, that would have lived longer, that would have been of more use to them. So,
Well, okay. Assuming you don't have a homeowner's policy with replacement cost value, you've just got a regular, you're talking about fair market value
Yep.
of a roof that's hailed out.
Okay.
Here we're talking about fair market value, correct?
Yes.
If you have a 20-year roof and 10 years into that it's hailed out, your fair market value is a replacement less 10 years depreciation. You amortize that out. So you would be paid a half of the replacement cost. Why isn't that concept? Because you wouldn't go out and buy 10-year-old shingles to reshingle your roof. So when fair market value here, you have a 2-year-old bull that's increasing the length of usefulness by 4 years. So why wouldn't you amortize that replacement value? I mean, the concept of fair market value being the measure of damages is the same whether there's a risk of trick or whatever, or used shingles might leak. So the concept's the same, isn't it?
But you can only sell the bull one way or the other. And we're not talking about an insurance contract. We're talking about a grazing
No, we're
contract.
talking about measure of damages and
Okay.
fair market value. And fair market value is the measure of damages here, isn't it? What
The value of what they would have had if the
Right.
contract had been performed. That's what we're trying to get them to.
they would have had a 6-year-old bull.
A used 6-year-old bull,
Right.
whether he was 2 or whether he was 22, his value is only for meat,
If you're going to sell them.
if you're going to sell him.
And I guess that's my question, and I just need to understand something about the cattle business that I
Well-
don't understand. Because if you have a bull that's able to produce, that you can breed, that's what they needed, was bulls who could breed, right?
Yes,
To replace.
yes.
So to them, the value is I need a bull who can breed, and I can't get one except by paying the higher price for the unused bull.
Okay, but the bull that they would use to breed at the end of the season would have been a used bull.
Right,
Right,
but he'd be their bull.
he'd be their
He
bull.
wouldn't need to sell.
Right.
Yeah, that's the problem. Okay, thanks.
More questions?
I've got one unrelated. If there is no market for used bulls, I don't understand all these individuals that lease bulls.
Yes.
I mean, that's fairly common. You don't want to spend the money to keep a bull, and you want to change the bloodline, and so you'll lease a bull. There's several outfits out there that lease bulls. And what's the difference of buying a used bull or going out and leasing a 6-year-old bull?
Okay, so a couple things. First of all, if I lease a bull, then maybe I don't have to take care of him for the rest of the year.
No, I understand the reason to do it. I'm talking with regard to trick.
Yeah.
The risk of infection.
And I would say most people aren't going to get a used bull, lease a used bull that's been used someplace else. They're not going to lease a bull that's been used someplace else. They might lease it for themselves as a virgin bull, but they're not going to lease a bull that's been someplace else. They're not going to lease a used bull.
Because the concerns about venereal disease.
Yes, sir.
Any more questions? Thank you, counsel.
Thank you all.
Reserve 5 minutes for rebuttal.
Thank you, Your Honor. Your Honor, I would like to address the issue of the bulls, the measure of damages concerning the bulls. And I think that's been fairly covered, but I do want to give the plaintiff's position on this, and that is that the bulls came back in bad condition. In fact, 2 bulls died, and 2 of the bulls could not be used again because of the extreme poor condition of their health. And when the 2 bulls that died, the only way, just as has been discussed, you don't go out and buy a used bull. The only way you can do it is you go out and you have to buy a virgin bull. The amount of the damage that was granted by the district court. and
Actually,
that-
you don't have to.
Excuse me?
You don't have to go out and buy a virgin bull. It may be prudent because there's not 100% testing for trick, but there are people that lease, and there are people that lease used bulls, and so it does happen. It could happen. It's just a choice of your clients not to take that risk.
Well, I would submit, Your Honor, certainly with my clients and from my knowledge of the industry, the cow-calf production business, that in most cases, these ranchers are going to buy a virgin bull. Your Honor has
I understand.
mentioned the leasing. I would submit that certainly in our area of Kansas that doesn't go on very often, if it does.
Right. But that's a perhaps a prudent choice. I mean, most people wouldn't put a 10-year-old shingle back on their roof, but it is a choice.
I would submit simply that's a possibility.
And there is betterment. I mean, the bottom line is there is betterment when you have a 2-year-old bull, perhaps, assuming they can produce as well as the existing ones. But you've got for life of service, you've got betterment, don't you?
But what else can they do? Now, I know the court's brought up the issue of leasing today, which was certainly nothing that was ever brought up in the trial of this matter.
Well, what you could do is you could amortize that betterment. And they lost a 6-year-old bull that maybe had 2 or whatever years left, and they replaced it with a 2-year-old. So you amortize the cost to put them back in a position of having what they lost.
I understand what Your Honor is saying, that could have been done, but we submit that the what is traditional and typical in the business, in that situation, you're going to go out and you're going to buy a virgin bull.
How much money are we talking about here? The difference between a 2-year-old and amortizing to a 6-year-old?
Well, as in this case, we've submitted, and that was ordered by the trial court, the amount of $4,500. And that would be the cost of a virgin bull.
Per virgin bull.
And in fact, in the two, I do want to make this clear to the court, that in the calculation of our damages, the two that were sold at salvage value, we figured the $4,500 less the salvage value. I think the court perhaps understands that or realizes that that's what we did in that case in the calculation of damages.
Had this contract been performed from your client's perspective perfectly and there was no problems whatsoever, at the end of that, your clients would not have had virgin bulls, right?
They would have had bulls that they'd have been able to use further. Yes.
And why would they be able, I mean, as I understand defendant's argument, they wouldn't have been able to be used other than for meat.
Well, we take issue with that.
Well,
That's not true.
just
They
help
would
me
not have brought
understand
the
how
bulls
that-
home and sold them for salvage. If those 4 bulls, the 2 that were died and the 2 that were sold for salvage.
Is the reason they would be able to be used is because they would be used with a herd that the...
Yes.
Okay.
And that's one thing that was brought out in the trial was the genetics. Each one of my clients, they have, and this is common in the business, cattle herds. They breed up they establish a bloodline.
So your argument is that this notion that bulls can only be used once is only true if they're herd hopping, in other words, and that's my language. But just help me understand how the...
Exactly, Your
That's
Honor.
the deal.
No, these bulls would have been used by my clients
Okay.
on their own herds again.
Thank you, that helps me.
That's a good point. I want to make sure that's clear. Yes.
Well, it's the difference between the utility value and the market value. What you're saying is no one else wants to buy them for anything but salvage value, but your client, they were worth more to your client to continue to use them.
With
And
their
so
own-
there's a difference
Yes.
in value, the value to your client to continue to use versus the value on the marketplace.
Yes.
Okay.
Yes. They certainly wouldn't have had to go out and replace bulls. I would also like to state in my rebuttal that the claim by defendant that Mr. Peterson vetoed the use of feed, the plaintiffs take issue with that. Perhaps that's something that I have not caught in going back over the testimony of this case, but I do want the court to know that plaintiffs take issue with that, that Mr. Peterson vetoed the use of supplemental feed for the cattle. And the plaintiffs also want to make clear to this court that the plaintiffs did have hired hands, specifically Mr. Peterson had hired hands go to Mr. Ferrell's ranch to look at the cattle. And also Dr. Bechtel communicated with Mr. Peterson and I think also Mr. Ladd and Eilert about what was going on with the cattle. So it's not as if they didn't care or they were informed of some problem and simply ignored it or vetoed something to be done about it. I do want the court to know that we take issue with that. And we take issue with the position of the grazer, of the defendant, that all he has to do is you bring your cattle down, you dump them out, and, that's it. That seems to be what he's saying, that I really, even though I agreed to monitor them, provide proper nutrition for them, I don't have any more responsibility to the owner of the cattle than to just, here they are at the end of the year, regardless of what condition they are. I don't see anything in the contract that says I had to give you back a animal of a particular body condition score. That doesn't make sense. I don't think that's logical. Certainly, if he's saying I'll be only responsible for cattle of a body condition score of 4, and I have the right to refuse any of those that are not, and to think that he has no responsibility to return a cow in that good a condition when they get back, that doesn't make any sense. And finally, Your Honor, the defendant has argued that there was evidence concerning what else could have caused the poor condition of the cattle and the less than standard, the 92% pregnancy rate standard. There was no evidence presented at the trial on the defendant's part to controvert what was presented to the court by the owners of the cattle as well as the veterinarian. And I think that should be made clear to the court. Thank you.
One last possibly unrelated question. What's the gestation period?
I believe it would be 9 months. I was raised on a farm and I should know, but I believe that's what it would be, Your Honor.
All right, thank you. Any further questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.